Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Sweet Maxwell, the Thomson Reuters publishing firm. It's an important book on insolvency. It's called The Law of Company Liquidation, and it's actually McPherson and Keay on the Law of Company Liquidation. It's now in its 5th edition, and it's been written by Andrew R Keay. I'm saying his name is Keay. Some people may say Key, but I believe he calls himself Andrew Keay. This is an important book for anybody, as I am, involved in matters concerning company insolvency and the way in which companies are wound up and so forth. I found the book very interesting. It's very much a part of the stable of books from Sweet Maxwell, a first-class book and where the law can be found. The title that Elizabeth and I gave the book review is Much Needed in a New World, the latest edition of the Law of Company Liquidation. And of course it's the 5th edition. Elizabeth was the lead writer and we wrote this review together. She put most of the work in. And we wrote it towards the end of 2021 as the pandemic is hopefully finally beginning to ease off a bit, but things have changed a great deal with the way in which we practice, and there'll be no looking back. We're moving forward. So what do we say about the book? Well, let's have a look at it first of all. It's a hardback, and it's actually in the Insolvency series. There's the front. You can see the Insolvency series mentioned there. Sweet Maxwell, of course, and all the details. It's a heavy book. It's running to something approaching 1,300 odd pages. Right at the back, there's actually something interesting. They've got a little bit of advertising. Don't normally do that with Sweet Maxwell and Thomson Reuters, but there's a little bit of advertising at the back and various other things that are available in the series, which I think is quite helpful. A number of publishers are doing that now. The index at the back is by paragraph numbering, so you should be able to find things quickly and navigate around. It's actually a detailed report, a detailed index, which is always very helpful, because I do find in company law, I call it company law, it is always very useful to have a good index at the back and a good index and content section at the front. There's the index, and it sets out the legal taxonomy, as it calls it, and it tells you how you can find things. And then you see right at the back you've got the last chapter, 1,200 odd pages there of that. At the front we've got the main front page there. Then after that we've got a dedication. The book first appeared in 2001. There's a dedication there. We only review books we like. We only review books we think are important and are good. There's no point in reviewing a book I'm going to slag off, because I think that's very unfair on the author. Having written books ourselves, we think it's quite right that we pay credit where credit's due, and if a book isn't very good, I'm not going to review it. Now, the foreword is written by Briggs. He's actually Chief Insolvency and Companies Court Judge, Judge Briggs. It's dated August 2021, and so it's a while ago now. Then there's the preface, of course, to go with the new edition. And in fact, Andrew has explained what is new. Then you've got the table of contents, and then after that, the contents, actually, I'll just run through. You can see it's very detailed. As I said, you can balance the contents with the index at the back, and you should be able to navigate your way through pretty well. What we've got after the contents is then the table of cases. Obviously, a lot of case law in this area. Running quite ahead, in fact, the table of cases. And get right to the end of the cases. Then the table of statutes, so you can see there's a lot of case law. Statutes, and then after the statutes, the statutory instruments there. Then after the statutory instruments, you then start with the main book. And you see the way it's set out. Excuse me, it's set out in the normal house style of Sweet Maxwell. So you've got the paragraph numbering at the sides, you've got a lot of footnoting, and it basically runs all the way through. And of course, as I've said many times, we can see the amount of footnoting is very substantial. As I've said before with all of these books, it's easier to read through the text without reference to the footnotes initially, because they do tend, they're very, very helpful, but they do tend to drive you down a path you might not wish to possibly go if you're just trying to get the general drift of what's being said. And provisional liquidation, there's a chapter there, chapter 6. You can see, so there's a very detailed work for which I'm very grateful. And of course, as I said, it's part of the Insolvency Library. Now, what do we say in a short review? Well, we say this. Be you lawyer or accountant, if you are in any way involved in matters relating to insolvency, you need this long-established and highly regarded work of reference. Out now in a new 5th edition from publishers Sweet Maxwell, and they're part of Thomson, Reuters. Company liquidation is referred to in the foreword by the Chief Insolvency and Companies Court Judge, Judge Briggs, as, quote, an important part of the insolvency landscape. It is axiomatic, he adds, that the law of insolvency continues to evolve, and world events such as the United Kingdom leaving the European Union and the pandemic have contributed to or hastened legislative change that requires the practitioner to have an understanding of new practices and procedures in what looks like a new world. And he wrote that last year, that's in August. Now, he makes a very important point, because we are really moving now ahead into 2022, and we've got to start thinking about what we're going to do, because we are emerging from the current pandemic, changed people, a very different way of doing business. London remains deserted for many, and a lot of cases, of course, are now being done via Zoom, the cloud video platform. I don't agree with that at all. I think they have to have attended parties hearings, so that's the way to deal with these cases. However, that's a matter for them and the civil service, but we are moving ahead. So we go on with the review by saying that while looking very much to the future, the book does illuminate with admirable clarity and thoroughness all aspects of company liquidation, including the winding up of solvent as well as insolvent companies. An important point, because not all companies are insolvent. You all know that. Note, of course, here that the editor, Andrew R Keay, points out that the terms liquidation and winding up are used interchangeably throughout the text. And I think that's an important point, because a winding up can either be a compulsory winding up or a voluntary one. And of course, the same with voluntary and involuntary liquidations. Now, a purpose of the winding up of both solvent and insolvent companies, he states, as the author, is to prepare companies for the end of their existence by eventual dissolution. Remember, they have a personality of their own, and to do so fairly and to do so equitably, particularly in cases in which there is a public interest factor. And in the words of Judge Briggs, this specialist text, this book here, explains the nature of winding up in all its forms and takes the reader on a journey through the intricacies, and there are many, of its processes. And frankly, it is confusing. I've done a number of cases in this area over the last 30 years, and I've always find something new. But there again, that's the same with most of my practice. So never assume that you know the answers in any case, because you don't. And you have to take each one. It's rather like being an actor on stage. Each time it's a new performance, and each time you may get something slightly different that comes into it. And certainly, of course, this book from Sweet Maxwell, it excels as a work of reference, to be expected, because they are an excellent publisher, and it's rendered easily navigable via the very detailed 16-page index, 16-page table of contents, rather, which covers the 18 chapters, and the 36-page index, which is at the back of the book. Also, there are about 160 pages of the tables of cases, statutes and statutory instruments. And of course, as part of the insolvency landscape, company liquidation is no one's ideal of a desirable outcome of business activity. But for lawyers advising clients who perhaps have taken risks, particularly in the current post-pandemic new world of business, the new edition of McPherson and Keay provides a comprehensive and indisputably authoritative guide to this difficult area of law. Now, the date of publication is cited as at May 2021, and I will say that although there have been additional dates given in the book, the actual date I think it appeared was then, although there have been a lot of delays in the publication of the print run of the books, because as I said, the difficulty you have here is when you look at the introduction, it's actually dated August 2021, and I think probably Judge Briggs added the foreword right at the end. So although the preface I don't think has a date, it doesn't actually have a date itself, but it's as I say, it's round about that time. And let's have a look and see where we are with the book. Right, commencement and effect of winding up. There's a chapter on that. So if you are thinking with your business of doing something like a voluntary winding up, this is a book you might find of help. It's not an expensive book by many standards, so it's worth doing. But I'd like to thank Andrew and everybody involved in producing this work. These books make our lives a lot easier as practitioners. A big thank you to all. Bye-bye.